We want to make it clear that Indiana is open for business. We want to make it clear that Hoosier hospitality is not a slogan, it's our way of life. It's the reason why people come here from around the world, and they come back again and again and again. Because Hoosiers are the kindest, most generous, most decent people in the world.
Everything in life, with very few exceptions, comes down to the law. Every decision has a private and often very public debate. And what is happening at the moment in the state of Indiana and now Arkansas is top of this list. While there are screaming battles over the intent and actions of the Religious Freedom Restoration Act, there are greater ramifications into numerous facets of business. And few seem to be willing to really take it head on. So let's get to it. Our guest is managing attorney at DCBA Law and Policy in Washington, D.C., former confidential counsel in the White House Office of National Drug Control Policy and veteran commentator on legal issues. We welcome Michael Barnes. We're also joined by senior counsel for the Becket Fund for Religious Liberty, protecting the free expression of all religious traditions. We welcome Eric Baxter. Gentlemen, thank you so much for joining us today.
Thank you.
Thank you.
Michael, I'm going to start with you first of all. As you read the law that has been passed in Indiana and Arkansas, seeing the language, does it in any way violate anti-discrimination law in the country?
Yes, the law as written in both Indiana and Arkansas can be used and could be used successfully to beat back anti-discrimination laws. So we've seen, for example, in states like New Mexico, that the laws of this nature, the RFRA laws, have been used to try to beat back anti-discrimination laws. Fortunately, in New Mexico, where they have a strong human rights commission and ultimately the Supreme Court of New Mexico made the decision, the result was in favor of people who want to just conduct their business and live life in normal ways, and not against the individuals who, it was not in favor of the individuals who were trying to discriminate. But we can't assure that that's going to happen in places like Arkansas, where we know that typically they're much more conservative and willing to discriminate.
Let me make sure that I'm right. You're saying that the laws as you read them in the two states are indeed in conflict with the anti-discrimination law, correct?
Yes, they can be used to beat back those laws.
Okay, Eric, let me get it to you then, because I know you fight for religious freedom. There you have it. And a lot of legal people are saying the same thing, that no matter how you slice it, this is meant to specifically discriminate against people of other lifestyles.
That's just false, and the level of misunderstanding is just incredible. And this law has been on the book for more than 20 years. It's federal law. It was even 30 years before that under Supreme Court rulings. It's never been used to justify blatant discrimination against gays or lesbians.
Then why is it being misunderstood? I mean, you said that, a million people have said that. What is the misunderstanding, Eric?
The misunderstanding arises from a very small area of cases where, the people involved in the wedding industry have asked not to participate in religious ceremonies that violate their own beliefs. I mean, it doesn't take a lot of common sense to know that a gay musician shouldn't be forced to perform at a rally for traditional marriage. But these laws have never been used in all that time to allow discrimination. All this law does, it doesn't decide who wins. It says that when there's a conflict between the government and someone's religious beliefs, the government has to show a compelling reason why it should be able to trample someone's religious rights. And sometimes the government wins those cases, sometimes it loses. It won in the New Mexico case, and it's won in every case where it's ever been tried to use to justify blatant discrimination. But that doesn't mean that there shouldn't be a discussion and a balancing of competing rights. And all this law does is allow for people to force the government to show a compelling reason before it tramples their religious rights.
Okay, let me get onto this, Michael. Let me come right back to you on this, because here it is again. Compelling reason to trample civil rights. What then would the government or anybody else come up with as a compelling reason against the language of the laws, the way they are written right now, to prove that they are discriminatory?
Well, if you look at what's different about these laws in Indiana and Arkansas, it's that they're written to allow for there to be a right of action or a defense in cases where the government is not a party. So that's one particular difference with these laws that needs to be addressed. But more importantly, these laws, as I already stated, can be used to beat back anti-discrimination laws. If you can say that you don't believe that you should be acting in a commercial setting in a way that is inconsistent with your religion, religious views, then you can use these laws then to justify your inaction. What the New Mexico Supreme Court said, and which makes sense to me, is that it's possible for anyone to have the right of free speech, for example. It's possible for anyone even to put a notice on a website saying our religious views are these. But nonetheless, those companies are required to act in a manner that is consistent with anti-discrimination laws.
Okay, I got to stop you there for 1 second because we've got something
allowing that to occur. They would actually prevent that sort of reasonable approach from
I got to stop you there, Michael, for 1 second. I understand where you're
businesses.
going with all the legalese, but we're short on time, and I just want to make sure, because you're getting to the core of this. When I was a kid, I grew up, and there were some people who used to put signs in the windows say, "We reserve the right to refuse service to anyone." Granted, that was 3,000 years ago. But what's wrong with people doing that now? The people who just say whatever it is and just stopping right there and saying, "I don't wish to service somebody at my establishment." Can't they do that?
Because that is discrimination, and it's not.
And
going
no
to that
court has
individual's
ever
religious
allowed.
belief
No
or
court
the
has ever
religious
allowed
right
someone to
speak.
do that.
Well,
The
that's
government
what
has a
these
compelling
issues are
interest
going
to
to.
prohibit
That's the question. That's why we
discrimination.
have to make sure that the law is not interpreted in states like Indiana and Arkansas to allow that.
Well, but wait a minute.
50 years, the law
my
has
reading
never
of these
been
laws
construed in
is
that
the
way.
purpose.
Gentlemen, aren't we assuming here, and again, we play both sides of this here, aren't we assuming then in many ways that there's discrimination here? Eric, I'm going to throw it to you because that's what Mike said and many other people here say. They say that if you refuse the right of service, that is immediate discrimination. Isn't that making an assumption?
Let me give you a real example of where RFRA has protected people's religious rights. If you are a kindergarten student in public school who's being told you have to shave your hair, cut your hair against your religious beliefs, if you're a Jewish prisoner who wants a kosher meal, if you're a nun who's devoted her life to caring for the dying poor and you don't want to use medical procedures that violate your religious beliefs, these are the real scenarios where RFRA has protected minority rights of religious belief. It's never been used to allow blatant discrimination. And the claims that it was intended to do that or that it would do that are just false.
But it could be used to
Great,
discriminate.
then I would assume that my colleague Eric has no problem with language that would outright prohibit discrimination on the basis of sexual orientation, in addition to race, religion, color, national origin, sex, and the other protections under laws that should exist to the extension of state law in places like Indiana and
Okay,
Arkansas.
good question here. I've only got
There are
15
no
seconds
protections
left.
for those people.
I've got
already
15
allows
seconds
that by
left, Eric.
requiring-
Please answer that question.
Yes, RFRA already allows for that. The government is on its strongest footing when it can show that the law is
Those
being
states
used
do
to
not
engage
have adequate
in blatant
anti-discrimination
discrimination.
laws. That needs to be
and
part of this if
there's
there's
never
gonna be any
been in
movement
20
forward.
years or the 30 years before that under Supreme Court law. Remember, these laws were enacted by President Clinton. It was sponsored
Okay,
by
we have to stop
Senator
it there because
Kennedy.
we are all out of time. But I'll tell you what, we've opened up the box here, and we're going to have to continue this again because I think that the questions raised here are very legitimate on both sides. We will do this again. Michael Barnes, Eric Baxter. Gentlemen, thank you so much for joining us today.
Thank you.
A new medical device that will change the way you think when scheduling that next important cancer screening. Next on MidPoint.